Today, we're going to talk about how to amend a trust and how not to amend a trust, with Exhibit A being the tragic death of Lisa Marie Presley. The estate of Elvis Presley was run through by his manager. And ultimately, when he died, there wasn't a lot of money, although he did still own Graceland, which became an attraction and generated a great deal of wealth. His widow, Priscilla Presley, had a daughter, Lisa Marie Presley, who in turn had two surviving children at her untimely death. The dispute that's arisen is that Priscilla Presley is challenging a 2016 amendment which removed her and an attorney as co-trustees of the Elvis Presley estate, and instead inserted Riley Keough, Lisa Marie Presley's daughter. Now, typically, if there is an amendment and there is a signature, the presumption is going to be that the document is valid, and it's going to be an uphill battle. And the reason that these are almost impossible to win is that typically with estates of this size, you have competent estate planning attorneys, and they have a very specific procedure that they follow to make sure that you have multiple witnesses that have seen the amendment articulated to the signer, that the signer acknowledges understanding what's going on. Sometimes these are even videotaped. According to Priscilla Presley, that wasn't the case here, that in fact there was no notary, there were no witnesses, her name was misspelled, and according to the express terms of the trust, the document that amends the trust is supposed to be delivered to the trustee. A lot of times courts are going to excuse that last requirement and really get to the intent. Was it the intent of Lisa Marie Presley to put her children in? And there might be some very good reasons to do that, as Priscilla Presley is elderly in her second half of her 70s, and her children are younger. But make no mistake about it, both sides will have their handwriting experts. One will say it's a valid signature, and one will say it is not a valid signature. And in fact, in the Facebook case where the Winklevoss brothers sued to get their portion of the company that was promised to them, there was an expert who testified unequivocally that certain emails were genuine when it was proven that they were not. So this courtroom drama will unfold unless Riley and her grandmother can find a way to make peace. But make no mistake about it, being trustee of a valuable and powerful trust involving the Elvis Presley estate carries a number of advantages, not just the right to make investments, but the right to be paid, the right to select attorneys. So this one likely will not be ending soon. John Belcher, Law Office of John Belcher, the Elvis Presley estate, Riley Keough versus Priscilla Presley.